Happy Friday. Just a quick chat today. Welcome to all who are following. Busy day. So just keep you for a little bit. So many big things this week. Let me start with a book recommendation. Some of you may have seen that I posted it, and I'll repost it here. Chris Summerfield, who's a AI scientist. I've, like many of you, been, trying to get myself educated, as a non-engineer, working with technology and reasonably comfortable, but I'm not writing a sample Python script to get further down the line. Not going there at this point. And a lot of the textbooks or dives start really getting focused on how to build, how the technique functions, embedding and vectors and transformers. And that's been helpful. But what this book, I'm going to just pull it up, AI, how chatbots learned to talk and the consequences of it, which I thought would just be a little bit more about the who's who and the different companies and that sort of thing, but actually walks through, and it starts with sort of Noam Chomsky, one of the most cited, experts on linguistics, and his theories of how language works, right? And when is it that a chimp who can, learn that certain words are going to get food and maybe even string together some combinations of words versus what it means to have knowledge embedded, and how language and understanding how language works reflects reasoning. And by sort of going through what that theory was like, and then sort of the counter theory of how the LLMs work, right? I think I was stuck, and I think many are, at sort of the level of, because it's seen so many words, it can predict the next word. And when you see, I posted sort of the roast, my friend Omer Tanay, leading privacy lawyer at Goodwin, and often a co-author with me of some of the more academic work that we've been done over the years. Omer asked ChatGPT to roast Jules Polonetsky, and the humor and the nuances of how it sort of tied together information that's available about me with different cross currents across my career, right? Like, who's made a joke about the fact that, I write about wine and I write about, privacy. You could have done a lot of different things. And so what he walks through in explaining how LLMs analyze language and use links between words and sentences and the entire context to do what clearly seems to be some different forms of reasoning really helped open my mind. Or you want a wine linkage? I have been, doing a lot of different tasting, but I recently had a De Montiel Pommard Burgundy, and I'd had some Burgundies, but this somehow made me understand what Burgundy was all about. It just had layers of texture, and it just, like, your mind starts thinking and racing as you drink this. And I don't have a super sophisticated palate. I'm interested in the history of wine, the winemaker, the region, the techniques. What's this wine supposed to taste like? And, I like it, but these people with these palates that give you all these forest floor and dark cherry and this and that, I just don't detect that much nuance, frankly. This was the first time where bouquet after bouquet and layer after layer just started unfolding. And this was a real aha insight. So I highly recommend the book, and it's posted a couple of days ago in my feed, but I'll repost it. It's again called something like, how chatbots learn to talk, and kind of what it means for all of us. Other big things that happened was a big thing that happened for me this week. And I haven't finished it yet. I've been going through it sort of chapter by chapter, and I'm going to reread it, frankly. Highly recommend. Some of the other news recently were the antitrust competition cases against Apple in Europe around the consent dialogue, ATT, as those who are all about this call it. And Apple, in its initial implementations, really had a very different structure for how third parties who want access to your device identifier, your advertising identifier, not your device identifier, your advertising identifier that Apple creates, have to go through a dialogue that they can't really control, that Apple pops up when you ask for that kind of information versus Apple's flow. Apple made some changes to that. But in any event, the courts, regulators actually in each of these cases argued that Apple was disadvantaging third parties versus its apps in how they could much more easily access this and how they could speak to the users, the language used, the defaults, and all that sort of thing. And so presumably what Apple is now going to do, which is getting advertisers excited, but they probably ought not to be that excited, is we'll need to ensure that it is not self-preferencing. Some of the opinions are very clear. They've got no objection to the privacy concept, but rather that Apple's apps were being treated in an advantaged way versus third-party apps, including apps that maybe would just do the same exact thing. If Apple Maps wanted the information versus a third-party mapping tool, they have a very different user experience. And so Apple will presumably create an equivalent experience, which might limit, frankly, its own access to that data, or create a way that users can say the same sorts of things, or users of companies, apps can give more information, make their case. But clearly, it's still going to be a clear opt-in, and clearly most people are going to say no, although maybe some companies will be able to make a better argument for why they should get it. Again, I hesitate for folks who are really thinking that the future is these unique identifiers, whether it's cookies or IDs, to recognize that things are moving very quickly, both in many directions. One, leveraging actual personal IDs, hashed email addresses, and others to create a unified ID system, and many sites that you visit asking for that information, and then perhaps sharing it and linking it up with other parties who have tracking information about you. That's happening at large scale. The IAB has announced its plans for a server-to-server type mechanism, a trusted server. There are already companies that share the first-party log file data that they have with other parties. The challenge is that it's not easy to link up all those different servers. So you might share with some ad tech company who now gets the data that you've collected as a first party, but whether or not they are in a position to link that up is limited if they don't have a identifier that bridges those things. So by creating sort of a trusted server mechanism, so this is a long way off. It would avoid all the cookie blocking, all the ad blocking, because third parties wouldn't be there. They wouldn't be visible. First parties would be handing over your data, just like someone who has your PII, has your personal information, might be just selling it out the back door in a different transactional way. This would set up a technical way that data is shared. Now, lots of privacy and trust issues here to navigate, and those could really prevent this from advancing. One amusing thing is that one of the arguments is that, well, everyone will respect these automated universal opt-out mechanisms that are increasingly being mandated. And so if you don't want your data being transferred in that manner, the regulators, lawmakers have sort of created a signal that everybody needs to comply with. Don't know how this is going to go, just sharing it for those who need to understand it. The IAB has put out information. We've had some briefings, and we'll be following it closely. Well, what else happened? The Telenor decision, was that already last week? But I do want to mention it. I usually have lots of faith in the Norwegian Data Protection Authority. Some very smart people there. They're international people, the technology people, very smart people on AI, on pets. They did have this recent DPO decision, I think, however, that was surprising to many. Now, look, every one of these DPO decisions ends up being surprising to many because I think the data protection authorities have a very clear version of the real strong independence and unique nature of this DPO role. This is a third-party auditor and many things that you would want for a real independent ombudsman. But obviously, lots of companies are also leveraging DPO for privacy advice. You're going to be consulting with the DPO as you should, and where's the line between that and saying, well, they're also kind of the privacy lawyer. And so this case where the DPO had other legal responsibilities, and that was one of the issues here, I think surprised many. So I don't have enough time to really get deeply into it. I enjoyed listening to the Grumpy GDPR podcast, and she does really great work, but she had a great interview, or Grumpy DPO, with Paul Breitbart, who went through two of them, a real thoughtful discussion, and I recommend it. I'll post the link to it later. But I do think this is one where it's hard to see how, there were problems clearly with compliance issues in generally, but some of the takeaways from the case, which seem to say that you can't own stock, right? That's like a tremendous disincentive when every other employee of the company, gets stock. Some challenges to whether or not owning shares is feasible. Doing other legal work, arguing that lawyers are often processing data. Maybe some are, but certainly many who are simply providing privacy counsel are not determining the means of the data, and you could clearly set up a structure there. So again, maybe that just wasn't documented well enough. Anyway, a challenging decision, and I think really making life hard, and encouraging people to use external DPOs. And there's value to that, obviously, but there is value to having a internal DPO, and it is something that ought to be encouraged. But I think this decision sends a somewhat discouraging note because of the many limitations that it puts on. Discussion this week and last about opening GDPR, and although the comments from McGrath and from Schrems and from policymakers seems to be focused on a very limited reopening, really focused on small entities and record keeping. I'd like to put on the table research, which I think is treated with some difficulty under GDPR, and it might be reasonable to take a look hard if we want to support innovation. And it's not simply about making it easier for big companies to sell your data or to profile you. How do we support research in Europe, which is a place where there's obviously a huge capacity and many leadership organizations, and long litany of ways that research can be conducted, but can in many cases run into limitations, particularly when sensitive data is involved. And sensitive data is often involved, certainly around health. And I'm not sure that the data spaces are going to solve that. And yes, research can mean building, AI, and these things end up being commercialized. But if we're going to worry that research ends up being commercialized, we're really kind of cutting our noses off, right? Research ends up being commercialized. That's how we get new products and drugs and so forth. The government's not in the business of doing all those things, nor are researchers at academic institutions. At the end of the day, these things do get into our public life. But the core elements of, can we learn from data? Let's have the law apply to what the people end up doing when they commercialize, but maybe have some greater flexibility to support researchers. So we're thinking that through. We'll see whether it's something that we can help point to some areas where some flexibility or even just some, again, differences in views among different regulators. My argument often is that GDPR is thoughtfully done, lots of work over quite a period of time. It ends up being the conflicts of laws, the different interpretations, or sometimes where DPAs have, in my view, taken much narrower views of language that I thought was interpreted more broadly. And again, some of that is because I spent much of my career as a privacy professional pre-GDPR, but we had the same words. We had national laws, we had the directive, and it's not novel that some of these structures, the basic structure of GDPR existed previously. And was that all wrong? Was that all just sort of ignored? There were interpretations or expectations about what language meant that had more flexibility than perhaps some of the new DPAs coming in and looking at the language in different attitudes were. So I argue what's more important often is sort of the consistency and understanding that when there are areas that clash, let's take a look at them and figure out how to resolve it instead of just leaving uncertainty. Well, what else is going on? Well, one thing that I'm following a bit is the competition and privacy debate more broadly. I mentioned the Apple cases, but we've got mandates for portability, but a very strong oversight system set up to try to ensure that parties who get the data handle it properly in all the European efforts. On the US side, I don't see as much sophistication being brought. The Trump administration has sort of modified what it's requesting in the Google search query, in the Google search competition case, for instance. But one thing that they continue to want is to see, the Department of Justice wants to see Google make available search data to some unknown collection of comers. And I talked in the past of how the AOL search data breach really was an important part in my career. I became the chief privacy officer as a result of the company wanting to strengthen privacy oversight, but lived through as a previously vice president for integrity assurance, lived through how we dealt with the release of those results, the problems related to the release. I do hope if proposed release by a researcher who wanted the data to be used by other researchers for valuable purposes, that we would have flagged it as, hey, you can't just put this data out there publicly, because here's how incredibly hard and maybe nearly impossible it is to anonymize search results. And so I take that as a given that search results have names and have passwords, have secret links that you've sent on to your friend to access photos or documents, passwords, immigrants searching for, I overstayed my visa, what's likely to happen? And, you put in your address, you put in your region, super hard. And it just seems like that's not part of the conversation. Now, maybe we don't care. Hey, it's going to go to parties who we will trust. But who do we trust at a time when data about immigrants is highly sought after in ways that I never thought was going to be available? The IRS, Social Security system, government clearly ends up being a major player interested in accessing that data. And, if you only give it to a couple of trusted parties, how do you know where and who they give it to? We recently, became very well aware that the telecoms, which all are mandated to have systems that law enforcement can, regularly request for data they have, legitimate legal process for, was being widely abused by foreign adversaries. Anyway, watching that case closely and hope that the privacy concerns weighing against the competition ones are going to be serious. We have added privacy versus competition to the annual DC Privacy Forum, second annual. Please register. It's almost sold out. You'll see it under events at our site. And we're going to have some experts who work at the intersection of privacy and competition. I routinely raise this to get it on the agenda of the international privacy regulators, meetings and different forums. And what ends up happening is everyone says, yeah, that's a great idea. And how regulators work with each other ends up being put on the agenda, right? Cooperation forums and so forth. And look, that's important, obviously. But whether or not the people who disagree have good ways to talk to each other isn't as interesting as there are conflicting values here, are there not? And how do we resolve the fact that there are advantages in being a holder of data, and what's the right way to enable other parties to compete more effectively without creating privacy issues or preventing them from having utility to data. Some of the payment directives in Europe, there is a opt-in for a user to say, hey, I want my fintech, my financial planning app or payments app to have access to the data that my bank has. But regulators on the privacy side have said, well, that consent does not work for your consent to actually then use the data, right? That was the problem with the Apple ATT as well, right? The regulators said that opt-in isn't necessarily then an agreement that you can go track and do all these sorts of things. And look, it's fair, right? But how do we resolve the fact that A, there is a utility problem, and B, in some of these sort of forced sharing ones where we don't even have users, consenting, how do we have any system that says data brokers, foreign adversaries, foreign governments, every kind of company possibly, is going to get that data and then be monitored forever to make sure they use it in an appropriate way. Anyway, super important, super hard. I'll close with two things. One, the Center for Strategic and International Studies just posted, I think, a really useful document looking at the state laws. There's been sort of this chatter, mostly around Washington, that some of the state AI proposals, including Virginia, are mini EU AI Acts. Now, when you look at the thousands and thousands of clauses of the EU AI Act and the relatively brief, Virginia AI Act, and the fact that that only covers high-risk data and so forth, I think anybody who works in the space knows that it's laughable. But people who I think ought to be smarter, are out there arguing that all of the state laws are these crushing EU AI Acts. And I think you can debate whether the state legislators are getting it right. But the similarities are, like I've said before, like a bicycle and a Mack truck. They've got wheels and, and they propel themselves, but the difference is so stark. But anyway, one of the senior scholars at the AI division of CSIS really took a hard look and did a comparison. And I think it's helpful, frankly, because some of these laws are passing and understanding how they're being scoped very much more narrowly in the US versus the EUA Act, I think is super helpful. But read it for yourself. I think that's it for today. Thanks for those who popped in. Oh, one more thing. I invited in a post people in the community, those of you who are listening and joining, some of you regularly, and I'm appreciative of that, to join me. Why should I be the only one who chatters away? Some of you have thoughtful points and comments, and some of you reached out. But let me repeat that call. Occasionally I invite VIPs, and we all want to hear from those big shots. But some of you, not that you're not VIPs, but some of you who are part of this community have a lot of expertise and interest. And so I will reach out. But if you haven't reached out and you're watching now and you want to join, we'll just pop this screen on. So there's a couple of people here, and we'll have an informal chat about the top issues of the day. Maybe I'll ask you in advance if there's something you want to in particular bring up, and hopefully we'll continue to inform people and have a good conversation. Anyway, happy Friday. I'll try to post some of the links a little bit later when I get through the next couple of meetings. And thanks for joining. It's a challenging time in Washington. People on my block, my kids' schools, all been laid off. Contractors, people whose income was tied to various not-for-profits. It's a huge part of the Washington D.C. Community here, and really sorry to see the impact on so many of them, and frankly on the government agencies they serve. Stock markets crashing, obviously, around the world. Challenging time. So my heart to those of you around the world who are also obviously being deeply impacted. Thanks all.